just want to point out, Rob has been talking all about all of our accolades, and there are two very important things and two distinctions that Mr. King has that no one else in our office can state. First, he's the only... Are you on? Okay. Am I on? Blue? Yeah. All right. Off to a great start here. It is on. Hello. All right. How's that? Is that better? All right. As I was saying, Mr. King has been talking about all of our accolades for the entire morning. And he has two that are very important. First, he's the only Hall of Fame athlete in our office. Second, he's known me since the day I was born. I guess three can claim that too. So I'm here to talk about VSSRs, and like Mark, I made an actual representation of what I looked like when I was younger. So who here knows what a VSSR is? Okay, it's about half the room. So a VSSR is a violation of a specific safety requirement. And this is something that's very important for employers. And so first off, I'm going to tell you about what we're going to talk about today. So here's the game plan. First, what is a VSSR? How do you calculate the exposure? Why is that something that's important for an employer? What's the process? Why is it different than a typical issue that we have in the administrative agency? What happens to the merit hearing? Why is that different than an actual hearing for a workers' compensation claim? What are the defenses that we have to VSSRs for employers? And last, what is the appellate process for a VSSR and why is it different? So first, what is a violation of a specific safety requirement? First off, as the name states, it is something that's has to be specific. You must cite to the actual code section as to what is being alleged to be violated. Most of you know that there is, well, some of you might know there's the Ohio Administrative Code, which deals with a whole host of different things that deal with workplace safety. Everything from how, what material ladder must be made out of, to different machinery, the process that has to be for that, what type of guarding is required on different machinery. The code, when someone files for a VSSR, they have to list all of the specific code sections they believe to have been violated. Additionally, they have to include a mechanism of injury in their application. And the one thing that is good, I know you've been getting a lot of news about employers and all, TT is not a fun topic. It's something that's construed in the employer's favor. So why am I talking to you about VSSRs? Well, since COVID, we've noticed that there has been an increase in this application process through the agency exponentially. And one of the reasons is that it deals with compensation, and it's another way that employees can receive some form of money. What does that mean for you guys? Well, this is something that costs money out of employers' pockets. It's timely, it's expensive, and it's intrusive. There's an on-site investigation to your place of work. So it's something that we have to address and we have to be very cognizant of. And the big thing is, you can't take your eye off the ball on these. You're welcome, Lori. Go Bucks! So, the opposing party, the claimant's attorneys, they have a general playbook when it comes to workers' compensation claims. First, they try to get initial allowance into the books. Usually this is going to be something like a soft tissue injury, a sprain, a strain. It's usually something that's a little bit easier to get in than something more difficult. Once they have that allowed, they can go for an additional condition. Maybe this is something that's structural. Maybe it's a torn rotator cuff. Maybe it's something a little bit more difficult. They try to maximize the amount of compensation. So that's going to be permanent partial, whether there's term, temporary total, like we spoke about, permanent total disability, working wage loss, any other form of compensation. When they maximize that compensation, they can then look to the VSSR. Because the VSSR is directly tied to the maximum amount of compensation that's paid into a claim. So, going back to the specificity requirement. It's literally in the title, violation of a specific safety requirement. Traditionally, this is something that when the application we filed, only one or two code sections would be filed with the commission. Now, there's a new approach. It's a shotgun approach. And so what we found is that employee or claims attorneys have been filing 70 different violation sections. I mean, it's ridiculous. And our job is to be Bug Me Bunny, plug that shotgun. Now, I mentioned this is a penalty provision. So if anyone here is a state fund employer, you need to be very aware of this as well. Because this is money that can come directly out of your pockets. It's not something that necessarily would go through a TPA. So when looking at the penalty provision, it's tied to the date of injury. Okay, so sometimes you might have a claim that has been allowed. It looks at the date of injury, and you look at the maximum compensation rate for that date of injury. You might have a situation where an individual might have a low AWW. Doesn't matter. We look at the maximum rate. So some of you have probably seen the Bureau of Workers' Compensation's, their compensation table. You have to go to the table and look at what the max rate is. Sorry, not the payable AWW or the FWW, but the max rate. And what's big about the VSSRs is that compensation that we're looking at is not just what's been paid in the claim, but it's all future compensation. So if a VSSR is found and 2 years down the road there's another period of TT, well, you're on the hook for more money. So what does this mean? How do we calculate the exposure? So for this instance, I'm going to just talk about, say there was a 2023 date of injury, okay? And you had temporary total that was paid out for 8 months. Let's say, for instance, this involved a rotator cuff tear. Someone was off of work, it's a compensable injury, they had surgery, they're out for 8 months. So you paid 32 weeks of temporary total disability. They filed for permanent partial disability, about 10%. So the max rate for compensation of 2023 is $1,149 per week. So VSSRs are paid out if one is awarded between 15 and 50% of the max rate. So when we look at 15% of the max rate and 50%, you're looking at between an additional $170 per week and $575 per week. So based on the temporary total alone, if a VSSR is found, the employer could be on the hook for between additionally $5,504 and $18,000. And that's just for a small amount. Like I said, there's also the permanent partial aspect of this. That 10%, that pays out as well if a violation is found. So the total exposure for this hypothetical that we're talking about is somewhere between $6,600 and $2,200. And that is, again, that is out of your pocket as an employer, in addition to all of the compensation that's being paid. Now, this also includes, like I said, future compensation. So this is something that is, as Elsa put it, into the unknown. That's not going to play, but okay. So what is the process for a VSSR? Why is this different than an actual workers' compensation issue, like an additional allowance or a C9? So first off, they have to file the application. The application, like I stated, has the different code sections. What's important here is the employer has to file an answer. And so typically you might have a C9 or something that goes through and you say, all right, well, we're not going to respond to it. It automatically gets bounced over to the Industrial Commission. Not the same with the VSSR. You have to file an actual answer. Once the application is filed, there's what's called the SVIU, the Special Investigation Violations Unit. They will compile a report. That report involves collating documents, physically going out to the site of the accident, taking pictures, potentially talking to witnesses, and they take that report and they file that with the Industrial Commission. The claimant then has 30 days from the date that is filed to potentially amend that application if they think there's additional code sections that need to be cited. There's a pre-hearing conference that happens before an SHO, and that involves just basically getting some of the procedural issues out of the way, whether or not someone needs to subpoena someone. And then there's the merit hearing. The merit hearing is a little bit different than a typical allowance because you're going to be directly in front of a staff hearing officer. VSSRs, you only get one shot at it. typically for an additional allowance or claim. You get your DHO, you get your SHO, then you can file to the Industrial Commission. They can refuse to hear it, which is what happens 99.9% of the time. The VSSR, you got one shot, SHO. The merit hearing is also typically going to last a couple hours. And it's usually going to be on the record. So there will be a court reporter present. So how do you defend one of these things? First, you have to look at the code sections. What's actually being alleged? The burden. You have to note the burden is on the claimant. We can look to witness testimony. Proximate cause. The alleged code, the violation of the code section has to proximately cause the injury. And that's something that doesn't always happen. Negligence is defense in certain circumstances to VSSRs, as well as impossibility. And last, machine malfunction. So first, the applicable code section. Now, I mentioned before that claimants have been filing the shotgun method. So for instance, just as a brief example, this is effectively a boom lift, JLG, cherry picker, whatever you want to call it, okay? So there are code sections that deal specifically with elevated platforms or elevated platforms on vehicles. Recently we received a VSSR application that it involved a JLG. However, they cited cranes as one of their violations. They also cited hoists. The JLG is not a crane. It's not a hoist. So these are all things that they cited just as a shotgun approach to say, well, maybe we can pigeonhole something in there. So looking actually at the actual code sections and knowing what these pieces of equipment are is critical to defending a VSSR. The details matter. Like I said, remember, these are specific. So an example of this, 4123.1502C1A. Yes, it's a mouthful. This deals with guarding over floor holes. They have to be 48 inches deep for the code section to apply. So when you go out on an on-site and they take out their tape measure and they realize the hole is 40.5 inches, is that code section going to be applicable? No. So that is another defense that we have. Good news is, this is not under the liberal construction of the law. So I think Mark has mentioned it, a couple other people. It's the anti-4123.95. 95 is something that's cited by claims attorneys all the time that says workers' comp needs to be construed in favor of the employee. VSSR is the complete opposite. Go Bucks. Yeah. I'm not biased, who can tell, you know? Witness testimony. This is something that's critical in a VSSR merit hearing. It's our opportunity as an employer to put someone who's an expert in the room with a hearing officer. They can describe what that machine does, what's the process. So this is something where we would actually bring in something from EHS, where we have any type of a supervisor, some type of manager that has a specific knowledge of the area. It allows us to talk to safety experts too, have them provide some guidance as to whether or not, for instance, the JLG is a crane, and whether or not there's applicable code sections. Like I said, proximate cause, this is something that arises out of case law. But the injury itself has to arise from the violation. And as Mark pointed out, the definition of injury is the medical condition. It's not the mechanism of injury. It's the medical condition. So arguing that the proximate cause is what caused the injury is necessary here. So under the Supreme Bumpers case, and that's what kind of established the proximate cause, you first have to establish that the requirement was applicable. We've gone through some of the things that are not applicable. Whether the employer violated that requirement, and whether the violation proximate caused the injury. Here's a quick, brief, another example. This code section deals with safe means of passage over conveyors. The entire code section states, where employees are required to cross a conveyor, a platform with standard guardrails and tow boards must be provided. So looking through the various aspects of this code section, what do we look for? Was the employer required to cross there? What does cross mean? What happens if the injury occurred after the employee had crossed the conveyor? Is this code section applicable? What's a platform? Does that mean 2 platforms? I would argue that means 1 platform. Like I said, what happens if the employee tripped after crossing the conveyor? That would show that proximate cause was not the reason for the injury in this case. Negligence is also a defense to VSSRs. And if an employer has met the code requirements, then negligence can be used to bar a violation. So under unilateral negligence, it's a concept that we have to determine whether or not it's an actual defense. There is no duty for an employer to have constant surveillance over your employees. Likewise, if you tell your employees clearly what they're required to do and they don't follow it, that can constitute unilateral negligence. Was there removal of a safety guard? So we had a VSSR recently where it involved a cutter very similar to the one that you see here today. The employee had removed the safety protection outside of it and was subsequently injured. So did the employee remove something that caused the injury? And if they failed to use the equipment safely? I mean, there are many times where an employer might provide safety equipment to their employees, and the employee might just not wear it. Impossibility is also a defense when we look to VSSRs. And for impossibility, it's a little bit different because that has to actually, there has to be a violation, has to be sustained before you can actually use the impossibility defense. So impossibility is effective if it is impossible to comply with a code section or compliance would have included the work, with some type of safety process prevented something from moving down your conveyor line. And also, for possibility, there can be no alternative means of protection available. The other defense, malfunction. Malfunction can be used if a machine malfunctions one time and it was not foreseeable. In looking at the appellate process, so I mentioned you have your one level of hearings before an SHO. To appeal that, it has to go through what's called mandamus. Mandamus was mentioned a variety of times, and it goes directly to the 10th District Court of Appeals. That's located in Franklin County. This can be a timely process. As an example, a VSSR was recently appealed. I think that the complaint was filed in June of 2022 to the 10th District Court of Appeals. We received the decision 2 months ago. It can take a while. And during that time period, if a VSSR is found, the employer is paying. So, what are the takeaways from today? First, VSSRs equal money. This is real exposure to all employers. Regardless of your size, this is potential money coming out of your pocket. You cannot ignore them. So whenever you get a VSSR application, it's very important to take that seriously. The words matter. What's being alleged actually matters in the code section and in the application. They are defensible. Now, the reason I chose How to Make a Goal Line Stand as the title of this presentation is those of you that watch football, sometimes will be watching a game where you might have the opposing party on the 1-yard line, and your team is trying to stop them. And they've got 4 chances to get into the end zone. That's what it can feel like when you have a VSSR. I have this application filed against me with 35 different code sections, and it seems like everyone's against me. But if you know the defenses, if you know how to actually address the code sections, proximate cause, they are defensible, and you can make a goal line stand. So with that, thank you very much. I appreciate it. That is my email. If you have any questions, please feel free to let me know.